to Mr. Ingram, let me tag on to you with this question then. If we were to come in and say, try to, adopt a different waiver, tweak it whatever way, the way I interpret it is, if we go in and do anything to our side, then this is kind of simple layman terms. If we go in and do anything to our side, then we're subjecting ourselves to a lawsuit if we exclude a population that we originally said that we would cover. But if the federal government has made any changes on their side, such as in changes to the law since it was originally enacted, does that thereby release us as a state and allow us any latitude to go back and make changes ourselves without exposing ourselves to a lawsuit?
That's a really good question. And the Supreme Court actually addressed this specifically. 7 of the 9 members addressed this in their opinions. They foresaw the chance that the federal government would roll back its funding commitment to states. And you have to keep in mind why the Supreme Court said the Medicaid expansion is optional. They said states couldn't foresee when they signed up for Medicaid back in the 1960s that it would be changed in this way to grant new entitlements to this able-bodied adult group. But it would be very difficult for the state to now say, well, we couldn't foresee that the federal government would break its promise on funding this, because the Supreme Court explicitly said, states, you can foresee this. And so that is exactly why the point that Ed made just a few minutes ago is so relevant.
And if I could just follow up on that, because this is exactly what I have said in Washington, is to say that the only certain way to clarify this, the only way to provide states with certainty and beneficiaries with certainty is for Congress to amend the statute, post the Supreme Court's ruling now, to transfer that, just if you did nothing else, simply transfer that within the title from the section where it's mandatory to the section where it's state optional. If Congress were to do that, then a state could go in and out of that expansion, and no one would have any grounds to sue, just as any other optional population today.
I would just beg the opportunity to clarify that the 7 of 9 did not address this precise question of whether the state can back out.
No.
Isn't that correct?
No, what I said was the 7 of 9 addressed specifically the potential for the federal government to renege on their promise. And given that the Supreme Court's decision hinges on the fact that states could not foresee changes to the Medicaid program created by the Affordable Care Act, it would be difficult for the state to then say, we could not foresee this thing that you told us could potentially happen.
Essentially, the argument is that if you got it in front of the Supreme Court, 7 of the 9 justices would say, we told you so. Now, that's not...
What the Supreme Court really did not say is, clearly did not say, that this becomes the Hotel California. And when you get in, you can't get out. And I think what we're having a Washington debate here about whether the Medicaid expansion becomes the Hotel California, whether Judge Roberts decides that he's going to change his role in history and unwind, today, easily one of those significant decisions that he's authored. I recognize the legal debate. It's a very interesting question. But the likelihood that we're going to face a Supreme Court who says, now that you are in, regardless of what we have said in our opinion, you cannot get out. Is that what you're arguing?
That is exactly the interpretation that the lawyers that argued the case took away from the court's ruling, that they had set up a Hotel California situation. I can give you the lawyers who argued the case. And that is the concern. Can anyone be definitive? No. That's my point. I cannot definitively tell you how the court would rule, nor can anyone definitively say that the court would uphold that the states could come and go from this expansion, because the ruling simply did not address it. I simply point to the fact that the Supreme Court did not strike the statute. The statute has not been amended.